Members, we have a quorum. I call the meeting to order. This is the Bills Committee on Northern Metropolis Development Bill. Please invite the administration to come in. Since the last meeting, till the deadline of the 31st of July, the Secretariat has received 6 submissions, namely CB bracket 1943 stroke 2026 bracket 01 and CB bracket 1971 stroke 2021 bracket 01 to bracket 05. On the 7th of August, another submission, number CB bracket 1989 stroke 2026 bracket 01 was received. All submissions have been forwarded to the administration for them to give a reply and for members to read. The administration has given us a consolidated response on these submissions. Please refer to CB bracket 1004 stroke 2026 bracket 03. Matters arising. The administration has responded to the follow-up actions arising from the discussion at the meeting on the 29th of July 2026 is paper number CB bracket 1104 2026 brackets 02. The LegGo's list of follow-up action paper is paper number bracket 1 CB bracket 1104 stroke 2026 bracket 01. Members, if you'd like to speak, please press the request to speak button. We will ask the administration to quickly go over their reply. Thank you. We have issued 2 papers since the last meeting to address the views expressed by members at the last meeting. Members asked us to set out in a paper existing legislation and administration, subsidiary legislation as well as administrative measures relating to the Northern Metropolis so that it will be easily comprehensible by members and members of the public as well as stakeholders. We have prepared the paper. The development of the Northern Metropolis spans over a decade, covering many different areas. It is impossible to address these matters with just one single piece of legislation or one single policy, so we need to make use of principal legislation, subsidiary legislation, as well as administrative measures to support the development of the Northern Metropolis. These different measures and legislation have their own respective purposes. We need to remove legislative barriers, and that will have to be addressed by legislation, namely the Northern Metropolis Development Bill. The bill will only apply to Northern Metropolis and not anywhere else. We'll also need to make use of legislation to set out legal framework and policy framework. The details will be set out in subsidiary legislation. This gives us flexibility to make adjustments. So we have the principal legislation setting out a framework on 6 areas, whereas subsidiary legislation will set out the details. The first batch of 5 subsidiary legislation has already been given to members. That's only the draft. They are given to members in aid of understanding the bill. If there is a need to make legislative amendments to remove legal barriers, in some cases, they apply not just to the Northern Metropolis but other areas as well, say for example the Inland Revenue Ordinance. Enterprises outside the Northern Metropolis may benefit from these measures. We will, in this case, make changes to existing legislation because that will be more focused and consistent. The FSTB will consult the LegCo on the IRO in terms of the overall framework. Enterprises in and outside the Northern Metropolis will benefit. There is another area, the economy. Of course, that covers not just the Northern Metropolis but the entire territory. The Transport and Logistics Bureau has already made some legislative amendments, say for example the small unmanned aircraft as well as the Air Navigation Hong Kong Order 1995. They are considering further legislative amendment to support low-altitude economy. That applies to the entire territory, and the Bureau aims to complete the drafting next year. There are some changes that do not concern the law but administrative side. But the administrative side, we have done a lot of work in this regard. Say, for example, under the Development Bureau, we have a steering group on streamlining development control. In the past 2 years, we have launched over 90 measures. This year, we have another dozen or so new measures. The steering group is chaired by high-level officials to provide policy steer. In addition, we have a permanent secretary chairing the dedicated project supervision office. Another administrative measure is labor importation. We'll do our work in the respective areas. Members are also very concerned about our work to attract businesses and enterprises. There is no need to worry. The most important thing for businesses is to have a one-stop shop to provide assistance. We have, in this regard, the Invest Hong Kong as well as Oasis. They provide one-stop service, making use of different measures such as dissemination of information or promotion activities. They obtain basic information from enterprises and then customize services to suit their needs. In addition to the 2 bodies I've mentioned, the Development Bureau also help to provide assistance. That is the key points of the first paper. The second paper is the response to the 7 written submissions we have received. There are 2 categories. One The first being more related to the bill, and the second more to do with the development of the Northern Metropolis. From the 7 submissions, we have boiled down the views into a number of observations. At this stage, we do not have any plans to extend the scope of the bill outside the Northern Metropolis, because the Northern Metropolis is unique. The second point is the streamlining of town planning procedures. That mainly applies to areas not under conservation. Section 16 application, even with a streamlining, still involved public participation. The Town Planning Board will be the gatekeeper. There are views saying that that should be dispensed with as well. Our reply is that, there is compression of time from 9 months to 2 months, but there is still a need for the Town Planning Board to gatekeep. Some views that is also expressed by members talking about concerns of streamlining on technicalities as well as impact on the environment. We will leave it to the Town Planning Board to address these issues. Flow of personnel. There are views saying that the scope should be extended to Suntin Technopole. We'll first focus on the loop. We'll start with that. If necessary, and once it's proved that everything is running smoothly, and if there is a need for Suntin Technopole to have facilitating measures for flow of personnel, then we may consider extending the application to other areas. Lastly, the principal legislation and subsidiary legislation. We now have the principal legislation in the form of a bill. The subsidiary legislations will not take effect on the day when they are endorsed. We'll keep the same time frame, that is 28 days plus 21 days, before they come into effect. The first batch of 5 have already been given to members. They are drafts. There is sufficient time for members to go through them. In relation to other suggestions relating to the North Metropolis, that they cover livability, compensation, and suggestions relating to streamlining, they have been covered by the paper. I'm not going to go into details. Thank you. Members who would like to speak in this area, each member will have 4 minutes, question and answers included. The first is Ms. Carmen Kan.
Thank you, Chair. Well, at the last meeting on the 29th of July, we set out in the list of our actions 3 items. That's A and B I'd like to speak on. Especially for item A, I'd like to have a comprehensive list for easy understanding. Now, in fact, I have read the response and it's quite similar to what's set out in the electrical brief. I want to be more specific. For example, what pieces of legislation will be amended, as well as a table for compare and contrasting the relevant ordinances. I want to have an overview for better understanding, because this will help the public and investors and consultants to have a better understanding of the approach. Because, in fact, the Law Society as well as electrical members have held talks so as to find out more about business opportunities in Northern Metropolis. So we need to level with the consultants and investors what legislative amendments are involved. So, frankly, I think that this response is just similar to the brief already provided. And the other point is this, about attracting businesses and investment. I understand that there is concern from the media as to whether tax breaks will be provided. Now, according to the administration's response, if there are two separate sets of legislation, there may be confusion. But then the dedicated legislation, in fact, in itself is a separate item comparing to, say, Chapter 131. Of course, we are breaking new grounds by removing barriers and obstacles, and I very much welcome the effort. But when it comes to attracting businesses and investment, say for the IRO, Chapter 112, I'd like to know whether there will be some specific provisions relating to Northern Metropolis. P.S. Thank you for the questions. Now, I've heard the members' question loud and clear. Now that we have a better understanding of the members' request, I think we can go back and further elaborate on the response, because the member is asking for a more specific response relating to, say, what legislative amendments will be involved. Will they involve, say, amendments to town planning ordinance, the land resumption ordinance, as well as the benefits such amendments will bring? So perhaps we'll go back and elaborate on our response and provide more information as requested by the member and the Bills Committee. Now, the second question is this. In terms of tax concessions, as the tax concessions will apply to the whole of Hong Kong, as far as we understand, the philosophy behind the policy is that the steering committee chaired by the financial secretary prefers to introduce a set of tax concessions applicable to the whole of Hong Kong instead of providing a special treatment for industries and businesses in Northern Metropolis. So the current thinking is to amend the Inland Revenue Ordinance so as to implement tax concessions in order to benefit enterprises that may help the government in taking forward development there. Right, as we will be looking at this in greater detail, I'd like to ask a further question. For example, the Chief Secretary for Administration led a delegation to visit the International College Town in Incheon, South Korea in March and April. And when it comes to the essential factors, we need to introduce tax concessions as well as tax holidays. We need to be specific. We're not just talking about some broad brush tax breaks such as halving the tax rate or providing a 5% tax rate. Now, I'm not asking for a specific yes or no answer at this moment, but at least perhaps as far as the law is concerned, in Division 7, perhaps you can include something as a matter of principle so as to authorize the Chief Executive in Council to introduce some special measures that will benefit only certain sectors, industries, or enterprises setting up presence in the Northern Metropolis. These will be the only beneficiaries of tax breaks under Cap 112. Now, this will help investors make the decision. For example, on the 13th of August, you also invited the sector to give views on the logistics park in Hung Shui Kiu, and they would like to know whether there will be specific measures that will favor their investment. Right. For this part of the meeting, I'd like everybody to be as succinct as possible so that we can move on to the clause-by-clause scrutiny. So basically, you should air your views within your round and for the secretary to go back and consider your views. It's for you to decide whether to answer the questions. Now, as far as the list is concerned, as we know, there is no preamble in this bill. So since this is a really groundbreaking bill for Hong Kong, this is the first piece of legislation dedicated to Northern Metropolis. You may wish to spell out in writing, in greater clarity, the background of the bill. And I will give you time to mull it over. But when it comes to item A of the list of follow-up actions, now I fully appreciate that that's the way the Bills Committee goes. You answer questions. But then, this is my solemn request. You should compile a list for the benefit of investors and stakeholders, locals or otherwise, what measures we have relating to Northern Metropolis, and you also refer to the 6 key areas and the relevant solutions. You've also prepared subsidiary legislation. We're given a draft for a preview. Now, coming back to your responses, I understand different pieces of legislation may be involved, such as tax concessions or some form of incentive as part of the package. So I don't want just a brief. I want specific details. For example, you mentioned labor importation as well as regulations, such as the steering group on streamlining development control and the progress it is making. All these are relevant to the topic, but they don't belong to the dedicated legislation. You need to spell things out more clearly. Say, how should I recommend to my client to invest here because of the various merits? Now, I don't think I've been given a very clear overview of the work involved. Now, say this is a dedicated legislation, but then there are problems to be resolved. We also enjoy advantages. You need to, so to speak, open the smaller doors, and you tell us that this can be done by way of administrative measures. Now, this is not a homework that will earn a pass. So as far as the law is concerned, I think you need to at least provide a preamble so as to level with the public what a mega project Northern Metropolis is and how attractive it is. Now, as far as tax breaks are concerned, we need to highlight our strength. Hong Kong already has a low tax regime. So is there any room to further slash the tax rate? I hope that you can give us a preview before we conclude our scrutiny work. Because otherwise, people are not given the full picture. We practice the common law, and sometimes the details may be well hidden and that it may not be very clear to everybody. So let's see if you have anything to add. P.S. Well, I'd like to respond by saying, first of all, that we appreciate where you're coming from. Perhaps you're thinking from the perspective of an investor who would like to invest in Northern Metropolis. An investor might wish to know, say, how they should secure a piece of land, the steps involved, the administrative procedures to go through, the tax breaks that the government may offer, as well as subsidies available. So, I've heard your comments. We'll go back and give it a thought. And we'll also rearrange the paper, perhaps, having heard your comment. So we'll follow up on your suggestion. The second point is about preamble. Well, I think this was discussed at the previous meetings. We understand that members would like to have the preamble section in the bill to explain the purpose of having dedicated legislation for Northern Metropolis. we haven't given a proper response so far, but we are working on it. In fact, we are seeking advice from the Department of Justice as well as the administrative wing. Now, the preamble may or may not be the right place to explain the background, and we may need to look for an alternative. It is not the right approach to do so. And we'll go back and think about it and then report to the Bills Committee. Ms. Jody Kwok. Thank you. Chairman, I have a question relating to the response to the list of follow-up actions. At the previous meetings, members mentioned the need for a list of legislation that need to be amended. And then according to paragraph 6 of the paper, now, if legislative amendments are necessary for implementing certain policies, then the government is of the view that the most direct or appropriate approach is to amend the existing legislation. Now, this is the principle adopted. Now, I think members have also given their views, and we have had so far a rather lengthy discussion as of today. My question is this: how many pieces of legislation, according to the administration, will be amended? What will be the scope involved? Because the legislative amendment exercise may have an impact on our scrutiny arrangement. So I'd like the administration to elucidate this point and give us more information. P.S. About amendments of existing legislation relating to this bill, I'd like to invite members to go to paragraph 3 of the paper. We set out the 6 areas. For example, streamlining town planning procedures. That means the town planning ordinance will have to be amended. Expediting compensation payments for land resumption. That means the land resumption ordinance will have to be amended. And also for Northern Metropolis development, one key area is to facilitate innovation, and that means the Buildings Ordinance Cap 123 will have to be amended. The 4th area is about noise control, specifically application for the construction noise permit. We will streamline the application procedures, and that means the relevant environmental protection legislation will have to be amended. So when it comes to amending existing legislation, I think I've just gone through the number of them. As for point number 5, facilitating cross-boundary flows of factors of production, this is a new arrangement and not related to existing legislation. As for number 6, again, a new arrangement. Now, we would like the principal legislation to include an empowering provision for the setup of new statutory bodies. Ms. Kwok, well, I understand that the previous meetings, members gave comments and asked questions, and so far, I think we're just discussing the concept. But we are concerned specifically how many pieces of legislations may be involved. What is the workload we're talking about? P.S. Thank you, Chair. We understand the members' point. At the previous 2 meetings, we had discussions on policies, and very often we discuss concepts. So things may not be as specific. When we come to the clause-by-clause scrutiny, I think members will have a better idea what concept will be involved. For example, about streamlining town planning procedures as mentioned, that means we need to amend the town planning ordinance, Cap 131, and that will involve 2 major aspects, such as a streamlined approach to applying for change of land use so as to compress the time frame from 9 months to 2 months. The other aspect relates to temporary uses. The validity period will be extended from 3 or 5 years to 7 years. So these are the two major proposals. Now, about the specific provisions, if we're able to move on to the clause-by-clause scrutiny, perhaps in a moment I can explain further to members. But I think we've covered the point a number of times in the previous meetings. Some members have made different requests. I think that you have heard them loud and clear, and you will go back and prepare another paper, and at the appropriate juncture, we'll discuss that again. Mr. Hong, come in.
Thank you. I have some comments to make first. Part 3 of the bill. There are 3 divisions. But it doesn't really touch on the commercials or business side. A lot of people ask, in the North Metropolis, what are the preferential treatments to do business or to work there? So there should be a 7th division covering business matters. Once it's set, it's very difficult to make any amendments. When you have another division, then you can set out the details in the subsidiary legislation. I support what Ms. Can said. In relation to development and application of technology along the Shenzhen River, I think we need to consider how to actually bring them about. There are also some matters facilitating measures of flow, one of which covers a flow of personnel. In University Town and Santin Technopole, we think that the flow of personnel will not be confined to just the Northern Metropolis, but these areas as well. So will you relax your measures or do something to promote it? These views have been covered last time too. The first comment we noted is related to a discussion we had previously. All I can say is that when it comes to tax concessions, it will be done through the Inland Revenue Ordinance to implement these measures to benefit the entire territory. We'll forward members' views to the relevant policy bureau for follow-up. The development of the Shenzhen River. I will forward the view to the relevant bureaus. If necessary, we will provide a response paper. The third comment is about flow of factors of production and the fact that it should not be confined to the loop, the river loop. We agree. What we have in mind is to start at the loop. If everything runs smoothly, and if we reach consensus with mainland authorities, we don't rule the possibility that these facilitating measures will be extended to areas outside, in other areas within the Northern Metropolis outside the loop. Speaking for the second time, Ms. Carmen Can, 2 minutes. I'd like to say something about C and the members and the members and administration's reply, that is, in relation to C under clause 21(4)(f) in relation to cross-boundary flow. My suggestion is that we will look at the detailed during the clause by clause, but I want to ask about the design. Clause 21, that is, a city in council may make subsidiary legislation for cross-boundary flow. Clause 21 is general with a wide coverage. 21(4) specified details. There are 7 items. The 7 items, well, I share the members' concern that is in relation to flow of capital, or, well, for data is, well, for goods and articles is transportation, and for data is use or storage. I think that when it comes to the details, you have to refer to clause 21. I think we may have to wait till clause by clause to have a better understanding of the rationale behind this clause. Permanent Secretary, Ms. Gan, you have fully understand and correctly a correct understanding of the clause. We'll talk about details when we go to clause by clause. I think members have expressed their views. We have finished with the policy matters of the bill. We now turn to clause by clause scrutiny. Please refer to the draft of subsidiary legislation. Let me remind members that we're not here to scrutinize the subsidiary legislation. The information submitted is for your reference only. If you have any views in relation to the subsidiary legislation, please raise them. On the 16th of July, the legal advisor sent a letter to the administration to ask about drafting matters. The number is CB-1880/2026/02. The administration has provided a reply, CB number 1956/2026/01. When we go to the relevant part, members may refer to these papers. The legal advisor may speak when we reach that stage. Members, I asked you to refer to the bill, which is CB2/2984/2026. We will look at the Chinese and English version at the same time. I'll pause at appropriate times for members to study them. I'll also ask the administration to make use of a PowerPoint presentation to present the bill. Well, if you spot any irregularities in the English version, please let us know. To move things along, the presentation will be in Chinese. We will not go through the clauses one by one of the subsidiary legislation. We'll focus on the principal legislation. If members have any questions on a particular clause, please wait until the administration has covered that clause before you ask your question. I now ask the administration to go through the principal legislation, the Chinese version. Please turn to C3222, the Chinese version, which is the long title. There are 4 parts and 2 schedules. The long title. It is a bill to declare certain areas as the Northern Metropolis, to provide for measures for facilitating the development of the Northern Metropolis, to empower the Chief Executive and Council to make subsidiary legislation for related purposes, and to provide for related matters enacted by the LegCo. Ms. Cunningham. This is the long title. It is about the object of the bill. The purpose is the same as a preamble, that is to state that the Northern Metropolis will be developed. There will be facilitating measures so that it will be elevated and incorporated into the national development strategy. I would like to incorporate a preamble to give more information about the background, explaining why there is a dedicated piece of legislation. The Secretary and the CE have mentioned on different occasions that this is a dedicated piece of legislation, especially for the development of the Northern Metropolis. I would like to have it on the record that I am asking for a preamble. I would also like to speak on this part. This is a piece of legislation. Yes, we can make use of other information as an aid. Please work with the Department of Justice to find a way to highlight the importance of this piece of legislation. I also want it on the record. Anyone else who would like to speak on this part? If not, please move to the next part. Part 1, Preliminary. First, short title and commencement. Bracket 1, this ordinance may be cited as the Northern Metropolis Development Ordinance. Bracket 2, subject to subsection 3, this ordinance comes into operation on the day on which it is published in the Gazette. That is, the majority of the provisions will come into effect when it is published in the Gazette. Bracket 3, Part 3, except sections 14 and 16. Part 4 and Schedule 2 comes into operation on a date to be appointed by the Secretary by notice published in the Gazette. These relate to facilitating measures. So we will have these provisions come into operation on a date to be appointed by the Secretary. Ms. Kamen-Khan. In relation to commencement, according to Bracket 3, it says that sections 14 and 16 will not come into operation when the other provisions take effect. That is in relation to technical memorandums, those relating to noise control. The legal advisor has raised a point about section 16. It is in relation to relevant provisions, that is, say for example, section 12 of Cap 400. It says that these will come into operation after 28 plus 21 days. Can you explain to us why does it work this way? Do we have to refer to the technical memorandum? Is this an exception of Cap 400? Well, under the existing practice, Once these provisions come into operation, on the next day, the Secretary may issue a technical memorandum. How are we supposed to understand this clause?
Who would take this question, please? Ms. So? All right, I'll answer Ms. Carmen Can's question. Now, for subsection 3, we provide that sections 14 and 16 will come into effect on an earlier day. This is for the Secretary for Environment and Ecology to issue a technical memorandum. So the TM will be issued beforehand. However, the TM will also specify an effective date, which will tally with the date of operation of the subsidiary legislation. We will also need to disapply the existing legislation, especially Section 12, because Section 12 categorically refers to the time frame of 28 plus 21 days, and the TM will come into effect exactly within that time frame. But then when it comes to specifying a date, we also mentioned that this could be 49 days in total or further extension. So we cannot go by the old approach. We need to come up with a new way so that the effective date of the TM will be identical to that of the subsidiary legislation. Procedure-wise, there's no change. After this bill comes into effect, the TM as well as the subsidiary legislation will be tabled in the Council on the same date for consideration, and then they will come into effect on a specified date, perhaps 49 days or thereafter. So there is no change involved. In the existing legislation, they respectively spell out the effective dates, but now we make use of the new provision in the new bill to appoint the date of operation. Mr. Nick Chan. I have a question on Part 1 preliminary, and then 1.1. This ordinance may be cited as the Northern Metropolis Development Ordinance. So this is the short title. This is actually the same as the title of the bill. So my suggestion is to consider the long title again and perhaps provide a more succinct title. Who will take this question, please, Ms. So? Indeed, this ordinance will be cited as the Northern Metropolis Development Ordinance. We have no plan to provide a new title because we don't want to cause confusion. But as the Permanent Secretary mentioned, we are actively considering the long title. Mr. Andrew Lam. Picking up on what Ms. Carmen Can asked. Originally, I wanted to put this question when we come to the stage of scrutinizing the noise control provision. But now that Ms. Khan has mentioned it, I want to say the following. If we're not clear about the procedures involved in the principal ordinance, then it will be very difficult to examine the provisions. Since we still have time left, perhaps you can prepare for our advantage, say details about noise control, as well as the technical memorandum. For example, under the existing mechanism, how much time will be needed? Because the aim here is to expedite the process for applying for technical memorandum. But first of all, we need to have an understanding of how complex the whole thing is in applying for the TM or applying for the permit. PS. Oh, Ms. So, right, I have heard Mr. Lam's comment. Perhaps when we come to that part of the scrutiny work, we will further explain to members. Ms. Carmen Can. Chair. Now, I'd like to go back to the previous answer about Division 4, especially on technical memorandum and the control of noise permit. I want to confirm with the Department of Justice that we're taking the right approach so as to avoid judicial challenge later on. We need this confirmation for our scrutiny work. Now, about the Secretary for Development, I see there is no definition provided in the interpretation clause. But then, when we go to Part 3, and this is only my observation, it's a drafting point, I see a definition for Secretary for Development. So perhaps the administration can explain why this definition is only provided in Part 3 and not earlier. Any response? Thank you, Chair. Thank you, Ms. Khan, for the questions. In Clause 1, we referred to the Secretary for Development. Now, this is very clear. There is no need to provide a further definition. In Part 3, however, there are a number of references to Secretary for Development. So we want to make it more succinct by referring to the Secretary for Development as Secretary in Part 3. Mr. Wallace, the Senior Assistant Law Draftsman of Department of Justice, just provided an answer. Right here, Secretary in Clause 3 refers to Secretary for Development. Is it possible that in other provisions, Secretary could mean somebody other than the Secretary for Development? Or is it that throughout the bill, Secretary only means the Secretary for Development? We provide that Secretary means the Secretary for Development only in Clause 3. Now, in Clause 16, there is a reference to Secretary for Environment and Ecology. So because of this, we provide a specific definition in Clause 3. All right? Any further questions? Ms. Carmen Can. Now, if we are going to make further amendments to some of the provisions, perhaps you can revisit this point, because as you explained, the word Secretary appeared 3 times in this part, and that's why you provide a definition in Clause 3. You find it to be appropriate, but drafting-wise, is there another way without having to refer to the same provision 3 times? Because Secretary refers to the Secretary for Development specifically in Clause 3, while we scrutinize other pieces of legislation before. Sometimes this interpretation applies to a particular part, the particular division, or or throughout the bill. So perhaps you can revisit this part, Mr. Ng. Thank you, Chair. Thank you, Ms. Khan, for the comments. Well, in fact, what Ms. Khan referred to is in our drafting guide. Now, if a certain term is used in just a division or part of the bill, then a specific definition will be provided as an interpretation clause in that part or division, so that readers will not have to refer to the beginning. Now, in different parts, the word secretary may mean different secretaries. It may not be appropriate to provide a definition in Clause 2, the interpretation clause. So to avoid confusion, for this word to be used in a particular part or division, provide definition only there. Right, my point is we're already in Clause 3, and the word is only used 3 times under Part 3. Is it really necessary to provide a definition just for this part? I think to avoid confusion, you can just put down Secretary for Development, because you need to explain, for example, if you do not provide a definition here, which secretary are you referring to in other provisions? Right, perhaps we'll go back and give it a thought. Yes, because there is a reference to Secretary for the Environment and Ecology. Let's consider this and perhaps seek advice from the legal advisor. Mr. Nick Chan. I support the latter suggestion put forward by Ms. Khan. I'm a lawyer, and I think it is not desirable to include a definition in the middle of the bill to define a term. So I think we should just follow the follow Ms. Khan's suggestion. Mr. Chen Xiu-hong. In fact, I have 2 questions. I wanted to ask the second question first. Here, there is a definition for the word secretary, which means the Secretary for Development. Now, I've read many bills, and I appreciate that the law draftsmen follow their drafting guide, and that if there is a reference to a particular secretary, then perhaps you should be specific about which secretary you refer to. Or perhaps the bill may only refer to one particular secretary. In that case, no definition will be required. But as we will come to the particular provisions, there will be references to, say, the Secretary for the Environment and Ecology and Secretary for Transport and Logistics. So I find it appropriate to provide this definition for the Secretary for Development. I don't think we should dwell on this point. I don't think it's a matter of right or wrong. So I prefer to be pragmatic. Another question is this. In fact, this is touched upon by the legal advisor, and that is about Clause 3. Website specified by the Secretary. This is a question asked by the legal advisor. Now, the administration was asked whether this will be provided in the subsidiary legislation. According to the administration, the Secretary for Development will spell out the areas concerned for the Northern Metropolis on the website. And we're talking about external communication. Say the website might specify NM001 as a particular area. But then for Clause 3, there is this word declaration. It starts by saying declaration of areas. That means you're telling the public something. And that the Legislative Council will be responsible for considering what is being declared. But reading clauses 3 and 4 together, I think the bill refers to a one-off declaration, and that is upon passage of the bill, the Secretary may appoint a date of operation and make such a declaration. But if there are subsequent amendments, then it's not the case of a declaration, because if we read Amendment of Schedule 1 in Clause 4, the C in Council may, by notice published in the Gazette, amend Schedule 1, then so on and so forth. Now, my question is this. Is it because of Clause 4, which relates to amendment of Schedule 1, the previous declaration will no longer be applicable? This will be provided on the website, and as such, for the declaration made according to Clause 3, it will come under the subsidiary legislation, not being scrutinized by members. And that for amendment of Schedule 1 in Clause 4, it will come in the form of subsidiary legislation. And that way, members will still have a chance to examine the amendment. Am I right?
秘書長請。係。
Permanent Secretary. Thank you. Mr. Chen's understanding is correct. 3 subclause 1 talks about the area of Northern Metropolis. Schedule 1 is referred to. It is a plan laid at the land registry. We have attached the plan to the papers given to LegCo. Yes, this is a one-off. Future amendments will be related to Clause 4. The CE in Council is empowered to amend the area of the Northern Metropolis under circumstances A and B. That will be in the form of a subsidiary legislation by way of negative vetting. Any other questions? If not, we'll move on to the next clause. Then it is interpretation. Land registry refers to the land registry referred to Section 2(1) of the Land Registration Ordinance. Northern Metropolis means the area declared as the Northern Metropolis under Section 3. Cap 131 means the Town Planning Ordinance. Cap 131 plan refers to a draft plan. 2. It refers to a partly approved plan within the meaning of Section 182A of Cap 131. 3. Is a plan that refers to an approved plan within the meaning of Section 182B of Cap 131. And B, it includes a plan of such a plan. Cap 400 means the Noise Control Ordinance, Cap 400. Ms. Cunningham, thank you. My concern is the same as that of Mr. Chen. Declaration. It says that a declaration is made under Clause 3. Legal advisor, please explain to us from the legal perspective that it will be a one-off declaration. Can it be done? That is, a declaration is made under the law. My second question is about Cap 131 plan. If we're in the trade, we will understand what is a plan, what is a partly approved plan. Under Section 1A2, bracket A and B, why is there a different definition here? How does it help in the streamlining of the procedure? Who is to take the question, Ms. So or Ms. Ho? Members have asked a number of questions. I would defer to the planning department about questions on plans in Roman 1, 2, and 3. The member's first question is whether a declaration can be made. Yes. Yes is the answer. This is a bill on the Northern Metropolis. We we need to have a way to declare the area of the Northern Metropolis. There will be a declaration made under Clause 3. Members of the public will be referred to Schedule 1. The plan is deposited with the Land Registry, designating the area of the Northern Metropolis. The plan is important because there are specific measures that apply to certain areas. We make use of a declaration to make clear the applicable scope of certain provisions. Now I defer to the Planning Department. Thank you for the question. I'll quickly explain about a draft plan and approved plan. The first version is a draft plan. There will be different zoning. The plan will be first approved by the Town Planning Board. When the plan is gazetted, there will be a public inspection of 2 months. Submissions may be made by the public. If there are submissions, hearings will be conducted by the Town Planning Board for these people who have made the submissions to state their views. The board will make a decision based on these submissions. The draft plan, the submissions, and the final decision of the Town Planning Board will be submitted to the CE Council for approval. When the process is completed, it will be called an approved plan. There is one type called partly approved plan. This was introduced in the amendment in 2023. When there are submissions on a draft plan, or when there are outstanding issues in relation to rezoning, say for example judicial review pending, the other issues will be dealt with first. The process will be followed. That is, the draft plan will be given to the CE Council for approval, save and accept that part. But so far, there is no partly approved plan in existence yet. Thank you. Any questions, any views in relation to this part? If not, please continue. Please refer to C3226, Part 2, Area of Northern Metropolis. 3. Declaration of areas described in Schedule 1 as Northern Metropolis. 1. The areas described in Schedule 1 are declared as the NM. 2. Where Schedule 1 refers to any plan, the Secretary must publish the plan on the website specified by the Secretary, and B. Must make a copy of the plan available for inspection by the public free of charge in the Land Registry during the hours when the offices are open to the public. 3. A plan certified by the Secretary as a true copy of a plan referred to in Schedule 1 is conclusive evidence of the area described in that schedule by that reference. 4. In this section, Secretary means the Secretary for Development. Ms. Cumming-Can. To B. A copy. Under Cap 131, there is the English word copy, but the Chinese term is the same. Are they the same thing with different Chinese words? Or is it more common to use the word 副本 instead of 副本? Bracket 3. Why is there a need? Because under Cap 131, it's mentioned that in certain legal proceedings, if a plan is signed by the Director for Lands, then it can serve as a prima facie evidence. But here it says conclusive evidence. Why is there a need for subclause 3? Perhaps we will hear from the DOJ first. Thank you for the question. Subclause 3. We have drawn reference of the District Council Ordinance in relation to the delineation of administrative district. There is a similar provision saying that if there is a plan certified as a true copy of the administrative area, it is conclusive evidence. We've drawn reference from that provision. In the future, if there is a dispute about the area of the Northern Metropolis or its plans in future proceedings, then we can make use of this provision to use a copy of the plan as evidence. As to the term 副本, 副本 copy, I'll refer to my colleague. Who is to take the question? Ms. Wong? The policy intent is to refer to a copy. We have drawn reference from more recent legal provisions. The Chinese term 副本 or 副本 copy are very similar. We pick one that is more common and more easily comprehensible. We think that the Chinese term 副本 copy reflects the policy intent. Ms. Kan. Subclause 3. It sounds like that it is incorporated to avoid dispute. If the secretary certified a plan, then there is no room for dispute. It may not be used in a legal proceeding, but in all circumstances. If our deliberation is recorded, it also helps the court in future dispute. It helps parties to understand why there is a need for subclause 3. The area of the Northern Metropolis is important because the bill is a dedicated piece of legislation for the area. So if a plan is certified by the secretary, then it's conclusive. I thank the administration for the confirmation. Anything to add? I confirm that Ms. Kan's understanding is correct. Next, Ms. Kwok Foo-yong. I would like to ask a question about 3(2)(a). That is, the secretary must publish the plan on a website specified by the secretary. In B, however, it says that the secretary must make a copy of the plan available for inspection free of charge by the public in the land registry. Hard copy says it is for inspection in the land registry. The soft copy is to be published in a specified website. How come that the website is not specifically mentioned? In English, it says must publish the plan on a website specified. So there is one single website. So is it going to be uploaded on the Northern Metropolis dedicated website, or will there be other websites? Which website should people go to see this important plan?
Who will take this question from the administration, please? Maybe somebody from the Lands Department. I'll try to take this question. Now, as I understand, Ms. Kwok's question is this. a copy of the plan available in the land registry. That's actually the existing approach under other pieces of legislation. After the Town Planning Board endorses a plan, according to the statutory requirement, a copy will have to be placed with the land registry. Since the plan will have to be made available by a government department or at least a official body, we will make a plan available at the land registry. As for the soft copy uploaded to the website, we want to keep things flexible. So upon passage of the bill, we will discuss with the Secretary as to which website the plan should be made available. Now, the member is very meticulous, and she has helped us read the English version. In fact, in English, it's a website, it's a singular, so that means we plan to make available the soft copy on one single website. Is that true? Yes, this is indeed our aim. Even if it's worded like this, a singular A website, we could actually have websites in plural form. But we want to keep things flexible, as the PS mentioned. We need to provide flexibility for, say, further changes to the names of websites. And for technical reasons, we may need to make such a change. So the best way to go by it is to publish the plan on a website specified by the Secretary, and then we will declare this the address of this website through, say, the government press release. Any other questions? If not, let me remind members that in fact we should read both the English and the Chinese renditions. So just to remind the Permanent Secretary and members, Mr. Webster. Thank you, Chair. My question relates to clauses 3 and 4, declaration of areas in Schedule 1 and amendment of Schedule 1. My question is on the legal status of the subsidiary legislation. Now, for clauses 3 and 4, they provide that the Chief Executive in Council may, by notice published in the Gazette, amend Schedule 1. Now, as for this notice, as I understand, it's not yet incorporated in Section 20 or clauses 23. Now, according to the administration's response, apparently this notice is subsidiary legislation. So it falls within here, clause 4. But this will also directly affect the public coffers when it comes to, say, land resumption, compensation payment, infrastructure, construction, etc. Now, if these are not captured by the fourth clause here, amendment of Schedule 1, then it's possible that the LegCo may be circumvented. So my question is this: can you explain to us before you make this amendment, or at least explain the financial implications before amending Schedule 1? So let me first clarify. For Clause 4, amendment of Schedule 1, by notice published in the Gazette, amend Schedule 1. Now here it refers to subsidiary legislation. I think the member just referred to Clause 23, which sets out the Northern Metropolis subsidiary legislation, and that does not include the notice here. Now, this is because for the subsidiary legislation in Clause 23, they only relate to Part 4 for specific purposes. As you can see, this is a miscellaneous provision, which means when we make the subsidiary legislation, we can specify the application of the legislation to a particular industry, Northern Metropolis, or a particular project. And that way we can narrow the scope of application to just a particular industry, sector, or project. This only applies to Part 4, whereas for Clause 4, notice published in the Gazette. Now, it doesn't fall within Clause 23's definition because we are not narrowing the application or the scope of application to a particular industry sector. So it's not covered by Part 4, Clause 23, but it doesn't mean that it is not a subsidiary legislation. In fact, Cap 1 of the laws of Hong Kong provides very clearly what subsidiary legislation means, and apparently the notice will be an item of subsidiary legislation. Now, the second point is this. The member asked about financial implications brought about by the amendment. Let me explain. First, we've provided a very tight framework as to what amendments it entails. For example, the CN Council may publish a notice in the Gazette to amend Schedule 1 in relation to, say, the area declared to be the North District or Yunnan District under the DC Ordinance, or say there will be several dozen plans in Northern Metropolis, the demarcations of which may change, and that we will need to make corresponding amendments to these demarcations. So we have provided only a very narrow scope. Rest assured, we're not going to make major changes to other matters. The other point is this. Now, according to our experience when it comes to subsidiary legislation, we need to go through the Legislative Council, starting from consulting the panels to the vetting procedures. So we will go by the same procedures for the upcoming subsidiary legislation. If there are no other questions, let's move on to the next one. Clause 4, Amendment of Schedule 1. The CN Council may, by notice published in the Gazette, amend Schedule 1 in consequence of A. An amendment to the area declared to be the North District or Yunnan District under the District Council's ordinance, or the exhibition or approval under Cap 131, that's the Town Planning Ordinance, or any amendment under Cap 131-2, a Cap 131 plan prepared for an area, any part of which falls within the area described in paragraph A. 5 members would like to ask questions. Let's start with Mr. Lam Chun Sing. Thank you, Chair. Schedule 1 relates to the boundaries of Northern Metropolis. Now, 4A is more accessible because when there is a change to the demarcation of the North District and Yunnan District, then certainly a corresponding amendment will have to be made. Whereas for B, I'd like the administration to explain further. It seemed to be relevant. The exhibition or approval under Cap 131 of any amendment, etc. I want to know how this will apply, because I remember having discussed one scenario, and that is, this may not fall within the Northern Metropolis. The majority of, say, a structure or a development area may fall within the Northern Metropolis, and that a little bit may be left outside the boundary. And in such a scenario, we'll take the inclusion approach. The subsidiary legislation as well as the ordinance will apply to the smaller portion falling outside of the boundaries. So I want to know whether this is the case. For the smaller portion, this will be included and considered as part of the Northern Metropolis development as well. P.S. Thank you, Chair. I think the member described a situation that is relevant to declaration of areas described as Northern Metropolis, whereas for Clause 4, in the future, the amendment could only relate to two scenarios, A or B. So let me explain the principles in the demarcation of Northern Metropolis. When we consider administrative districts, they will be respectively the North District and Yunnan District. So that's two districts and the relevant demarcations under the District Council's Ordinance Cap 547. The other scenario is this. That is, plans covered by Cap 131. These plans relate to the Town Planning Ordinance. So we're talking about plans relating to the Town Planning Board. So if there is a plan under Cap 131 that relates to the North District and Yunnan District in principle, they will be included as well. Now, referring to what the member said, let me give you a specific example. For this plan relating to Hong Shui Kiu, a large part of this plan falls within the Northern Metropolis. There's a small portion that is left outside, and we need to make a decision here. If the majority of this plan is within Northern Metropolis, then this whole plan will be considered as part of Northern Metropolis. But let's say if there is a plan, the majority of which falls outside of Northern Metropolis, then this plan will not be included. So members may be concerned about this. There may be parcels of land originally falling under the administrative districts of Yunlong and the North. And does it mean that these land parcels will not form part of Northern Metropolis? And that means the relevant stakeholders will not benefit from, say, the streamlined procedures or compensation payment procedures in the subsidiary legislation. However, I want to explain that we're only talking about a very small number of such land parcels without much development potential. They could be, say, in the green belt zone or country park zone, and we find this to be a reasonable approach. Next, Mr. Chen Xiuhong. Thank you, Chair. I have a number of questions, Chair. Ms. So mentioned amendment of Schedule 1 in Clause 4. The Chief Executive in Council may, by notice published in the Gazette, amend Schedule 1 in consequence of the following two situations. Well, the director mentioned that a prudent approach will be taken. However, since the purpose is to remove barriers, what happens if in the future we want to expand the Northern Metropolis? The Permanent Secretary just now mentioned that they checked all the plans, and we've pretty much covered all the areas involved. But shouldn't we provide flexibility? That is, for the Xi Council to make such amendments as they think fit, something like that. Well, of course, the Legislative Council also has a role to play, either to go by the positive or negative vetting. I want to understand. I want to have an explanation of the thinking behind, and also, Mr. Lam Shin Sing asked a question earlier. As I understand, that for the small portion of the plan falling within the northern metropolis, whilst the larger portion falling outside, as described by the Permanent Secretary, the exclusion approach will be taken. That means the smaller portion will not be considered as part of northern metropolis, and then when amending NM 001, the Xi Council will make this corresponding amendment. So my question is on what constitutes a small portion and vice versa. And here, you refer to any part of which falls within the area. So it's not a matter of being small or large. It's up to the chief executive to decide on the matter. So, for an applicant to check the OZP, the applicant may find it confusing. So, why are you taking such a vague approach? Or is it drafted according to your guide or some references? Because the PS earlier explained to us, as per paragraph 5 of the electrical brief, as well as your PowerPoint presentation, paragraph B, you gave a very clear picture. So why not include that bit in the bill as well? Why is it that the Xi Council could make amendments without explaining the matter very clearly?
Permanent Secretary, the member has asked 2 questions. One is the reason why we have exercised restraint in drafting Clause 4. The bill is a special piece of legislation. It applies to just the northern metropolis. The streamlined procedure, special measures, if they apply to other areas, then it doesn't show our intention. Neither will it show the special status of this bill. When we change the boundary, if we specify the circumstances, then I think that it shows the uniqueness and special status of the bill. We do not extend these special measures without good reasons to other areas. The member asked why we did not state the purpose of the bill in the preamble. But we have already set out the principle at the beginning of the bill. And we have already explained and set out the principle in other papers. Therefore, there is no need to repeat it again in the bill. May I follow up on the first question? If in an OZP that there is a small portion of land that falls within northern metropolis, then it will be excluded in NM 001. But in Clause 4, there is Cap 547, District Council's Ordinance. This pertains to where the constituent should vote. So as I said, if there is a small portion of land that falls within the Northern Metropolis with the larger part of the land falling outside, the small portion will be excluded. Will it have an impact on the implementation details of Cap 547? Will it affect the constituency? Permanent Secretary. This is a piece of dedicated legislation for the Northern Metropolis. This will, whether it is included in the Northern Metropolis or not, it will not affect the delineation of district council constituencies in the Northern District and Yuen Long. Mr. Ken Lee. Clause 4 talks about amendment. It also talks about how it is to be published. It is by notice published in the Gazette. There are two specific circumstances that set out A and B. But it doesn't say anything about the procedure. Just now, some people said that they would like to set out a tight framework specifying the circumstances under which amendments may be made. So, is any amendment to be moved by the Secretary for the Legco to read the bill the third time before it is passed? Permanent Secretary, the member's understanding is correct. If the amendment is not within 4A or B, then yes, we have to amend this bill. We fully understand the consequence, but we have balanced different considerations. We want to send out a clear message. The facilitating measures, preferential measures, only apply to the Northern Metropolis. We will not, without strong justification, change the area of the Northern Metropolis. Anyone else? Next, Mr. Andrew Lam. Well, I think that in the description of the amendment, perhaps you are too serious, giving rise to concerns. There are pros and cons. Without a full understanding of the current operation, then you won't easily understand what B means. I have to read it 3 or 4 times before I got an idea. If the area of the Northern Metropolis as described in Schedule 1 is to be expanded, then it will have to go through subsidiary legislation to change the plan. You have set out in Clause 4 the specific circumstances under which the area can be amended. And these circumstances are there to restrict the government. B is related to A. So under the District Council's ordinance, if the area is changed, then the plan under B will have to be changed as well. That's how I read the two subclauses. The PS said that there will need to be a change, but my understanding is that it is not necessarily the case. Permanent Secretary. What I was saying was that if the area of the Northern Metropolis, if the amendment is neither A nor B, then there is no alternative but to amend the principal legislation. A and B, I'd like to say, can be read separately. A is in relation to the delineation of the two administrative districts and their changes. B is the delineation of it is the boundary of the OZP. They don't necessarily relate to one another. Mr. Lam, I understand that on the face of it they are separate. However, B is actually related to A. If the boundary of an OZP doesn't touch on a district, administrative district, then they are irrelevant. It's just like it won't be related to the Hong Kong Island. B refers to the OZP. So in this OZP, there will be areas that are the areas will either be within the North District or the Yuen Long District. Then if there is an administrative area that is in Sha Tin, then B will not be relevant. Ms. Carmen Can. The area of the Northern Metropolis is very important. That means if there is no amendment, then we only have to refer to Schedule 1, that is NM001, the area depicted in pink, as well as the Shenzhen Bay Hong Kong port area. The interpretation of A is that, my observation is that the CE in Council is not given of unfettered power. If there are changes in the delineation of the administrative districts of Yuen Long or North District, then the schedule the plan will have to be changed. So there is kind of gatekeeping. It's just like on the 15th of July. Well, if the river loop is incorporated within the area of Yuen Long District, then it is certain that it is within the Northern District because it's changed under the District Council's ordinance. So you will have to first make amendments to the areas under the District Council's ordinance. My observation of B is similar to that of Mr. Chen Xiu-hong. The Secretary and her team says that there are times that if there is a small portion that is outside the Northern Metropolis, then it will be seen as the Northern Metropolis. And if there is only a small portion falling within the Northern Metropolis, then that small area will be excluded. That is the idea given to us. But B doesn't mention about the size of the land parcel. Here it talks about the exhibition or approval of any amendment. It doesn't talk about the size of the land parcel. It says that if it is prepared for an area which falls within the area described in within the area in Yuen Long or the North District, it doesn't mention about the size. So, there is no clarity. Do you have to refer to the exhibited or approved plan? It doesn't talk about the size of the land.
So 專員
PS or Ms. So? PS. A large portion or small portion. This is an issue to be dealt with as we prepare the boundaries of Northern Metropolis in the first edition. That is, we start with the administrative district set out in CAP 547. We also have some statutory plans. Some of these plans include the North District or Yuen Long District. So as we prepare the first draft, we had to decide, for example, if the land parcels go beyond the demarcation of Northern Metropolis, should they be included? Now, I think I forgot to answer Mr. Chan's question on the definitions of large and small portions. When it comes to large portion or the majority, we're talking about something over 90%. And for small portions, we're talking about 1 to 2%. For example, a strip of land between, a strip of land between two plants without development potential. And because of that, it doesn't have any major impact if the strip of land does not fall within Northern Metropolis and hence not benefiting from the preferential treatment. Now, I answered the question about this large and small portions, and that the issue should have been handled as we prepared the first draft. Now, coming back to the scenarios A and B under clause 4, say for scenario B, when it comes to an amendment, at that point, we have to decide whether to amend the delineation of Northern Metropolis. And perhaps I'll give the floor to my colleague to explain why there are different scenarios relating to exhibition or approval under CAP 131 and the amendments. Let me explain this. The first plan is one with a pink patch, and we've included 41 plans. Now, for future scenarios, one possible scenario is that the 10ZP may be extended for the purpose of development. For example, a slight extension to Hong Shui Q, and this may encroach on some of the land within the Yuen Long District. And if we want to amend the OZP and incorporate the land extension, then this will be captured by scenario B. Ms. Khan. Right, thank you for the clarification. I think you answered Mr. Chan's original concern. And that is, we should no longer be concerned about whether it's a large portion or a small portion. This should be dispensed with in scenario B, actually, or else there would be ambiguity in the provision, because the decision has been made. In NM001, there is an area shaded pink, and that is the boundaries of Northern Metropolis. And then, like the planning department said an amendment will be made under B. Ms. So, anything to add? No? Mr. Lam Chun Sing. We agree with the principle of the policy. We're not trying to argue that the small portion should also be included in the plan. We're not suggesting that. We find it to be reasonable as well. We just want to see if the reality is well reflected in the provision or whether this can be implemented. So, as you said, if it's a small portion falling outside of the Northern Metropolis, then it's not regarded as part of the Northern Metropolis. But in reality, this piece of land may be may sit well in the Northern Metropolis, and the relevant laws and regulations should be observed. According to the District Council's ordinance, this area may fall within the administrative district of, say, Yuen Long. You may say this doesn't happen in reality, but indeed, say, in scenario A, when it comes to, say, a noise control, when works are in progress, is it possible to observe the relevant NM regulations instead? P.S. Thank you, Chair. In fact, we considered the scenario mentioned by the member. Perhaps we won't reach that part today, but when we go to part 3, when we discuss further the town planning matters, we can further explain the matter with reference to some provisions. Like the member just now said, he asked about how we handled the matter. If some of the issues relate to areas that the Northern Metropolis Development Ordinance applies, then what should we do? Well, perhaps when we come to that part, I will refer to these provisions. I'll be the next member to speak, but I'd like to have members support that we might need to extend the meeting a little bit so that I can ask my question and hear from the Secretary. Now, my question relates to a very important part, and that's clause 4 in part 2. We should not underestimate the issue involved, whether it's a small or big portion, even if it involves just a tree. And in fact, we came across this case during the avian flu. Even if we're talking about one chicken, it's still the property of somebody. A tree belongs to somebody. So when it comes to plans in clause 4, we need to be very careful. And that's the same for administrative districts as well. I think you should avoid the references to, say, large or small portion, 95, 96%. My question is this. Is there any similar reference in other provisions or in other ordinances? Because otherwise, I don't think matters should be left so vague. We need clarity. Perhaps when you formulated the policy, especially relating to the work of the planning department, at that time you made the decision already. So you need to level with the public and give them clarity, because otherwise things may be blown out of proportion, because we're not talking about just a small parcel of land. We're talking about the preferential treatment and the policies involved. So clarity is, or certainty is key. Perhaps you should explain that the area of Northern Metropolis will not be subject to casual amendments. This is very important, because otherwise you'll be subject to a lot of criticisms and queries. Because it's common wish for the area to be expanded. You need to draw a very clear line. Don't leave any room for imagination. As far as the law is concerned, things are certain. Here's the delineation. We are scrutinizing this bill, and clarity is key. We're being watched by the public. Everyone are having eyes on the plan. So my suggestion is to avoid this kind of reference. Since you have a professional works department and you have the plan, I think we had a very meaningful discussion about Clause 4 today. When it comes to Northern Metropolis, it's essential that we consider everyone's entitlement. So my question is simply that you provide a very clear record that the area will not be changed arbitrarily. Frankly, I don't think you should put down 98%, 99%. As far as the law is concerned, you need to have certainty. P.S. Thank you, Chair. I fully agree with you on matters such as clarity and certainty, and this is also the principle that we adopt. The planning department just now explained that we are certain about the number of statutory plans to be included in the Northern Metropolis. Now, I want clarity as well. I'm going to provide a response in writing to explain in greater detail what the 41 statutory plans entail. So things will be crystal clear. We will also answer the other question, and that is for plans with only a small portion falling within the Northern Metropolis and hence excluded. We'll further explain what these small portions refer to. We checked everything. Even if we haven't included these small portions, there will not be a major impact because these are, in fact, land parcels belonging to the government without development potential, without anyone interested in taking forward development. There may be a question on changing land use and whether a streamlined procedure can be taken in applying for the change of land use. But since the majority of the small portions is in such a situation, there will not be an issue of land resumption or expediting compensation payment. I will provide a written response as quickly as possible for clarity's sake and for certainty's sake so as to follow up on members' questions. Right, I'm happy to hear from the PS that greater clarity will be provided. You just explained that, in fact, you're certain about the plans to be included, and you're certain about the decision-making process. Now, when it comes to development potential, however, I'd like to share with you my experience. I brought a delegation to visit a site that is actually not sought after by any bureau or department, but is suitable for some high-tech development. So perhaps you think there is no development potential, but after all, you can just represent yourself. There may be changes and that the land parcel may become one with potential. So you explain the principles, your policies, and how you've come by your decisions. And I can tell you, this experience that this unwanted land parcel that I just came across in the past year, because of technological changes, people's interests also changed. I'm happy that we have had such a fruitful discussion today. So at the next meeting, PS, I appreciate if you could give us some clear information. And that wraps up today's discussion. The next meeting will be held on the 24th of August, Monday at 10:45 a.m. Thank you.